Hello, dear CA Foundation student. How was your weekend? I hope you were busy studying. Yes, just a month remaining for your exam. Yes, we are continuing with our revision sessions. Today I was going to take a live session, but I had a lecture in the evening, so I couldn't cancel that. And I didn't want to miss your lectures also. So I thought, why not go for a recorded one today, right? So today we'll study through a recorded session, tomorrow also a recorded one, and then from Wednesday we can again meet for a live session where we will continue with Partnership Act. Okay. Chalo. Now we were discussing breach of contract. We had discussed 4 units of Contract Act, and the only units remaining are breach of contract, contingent, and quasi contract. So today that I'm going to cover that in today's session. So quickly let's get started. Yes, breach of contract. Now, what is the meaning of breach of contract? Let's do a quick revision, okay? Because breach and quasi and contingent contracts are very simple chapters. They are very important for exam. You need to know all the concepts, but yes, they are easy. I'm sure you're aware of them. So let's quickly go through them. Breach of contract. Yes, what is the meaning of breach? Breach means when one party either fails or refuses to perform his promise. Okay, he fails or refuses. There is space over here, so I'm going to write a small chart for you, and in that chart we will cover the entire concept of breach of contract. Okay, so let me write the chart here. You can pause the video later and copy it. So breach of contract, it means that when the party fails or refuses to perform the promise. You can download the chart book. Link is given in the description box. Just go and click on that link and you'll be able to download the revision book for free. Yes. So breach means when one party fails or refuses to perform his promise. Now let's say, for example, that X promised to supply goods to Y on 13th of April and Y promised to make the payment on 15th of April. Now X fails, okay? He fails to send the goods on 13th of April, or he refuses that I'm not going to send. It means he has committed breach of contract. Breach may be either actual breach or anticipatory breach. Actual breach means breach which is committed on the due date of performance. Okay, it is on the due date of performance. Actual breach may be during the course of performance. During the course of performance. Okay, so actual breach may be either on the due date or during the course of performance. On the due date, it means that X on 13th itself, he refuses to send the goods to Y. It means he has committed actual breach of contract because it is on the due date. During the course of performance means party has performed part of the promise, but he fails or refuses to perform the remaining part. So let's say, for example, that X had promised to supply goods to Y in 3 installments. Okay. He supplied the first installment. He gave the first installment, but he refuses to send the second and the third installment. This is actual breach of contract during the course of performance. So he has performed part of the promise, but he fails or refuses to perform the remaining part. This is actual breach during the course of performance. Now, what is the remedy available with the aggrieved party? In this case, the aggrieved party can immediately cancel the contract and claim damages. Okay, so you can terminate, you can rescind the contract, and you can claim damages. In order to claim damages, you need to rescind the contract. You cannot both keep the goods as well, you cannot keep the contract as valid and claim damages. You have to cancel the contract. So you will rescind the contract and claim damages. Now, what are damages? Let's say, for example, that the contract price which they had agreed was 100 rupees. So Y was going to get the goods for 100 rupees. Now X refused to supply the goods. Y had to go to the market. In the market, the price increased to 120 rupees per unit. Now Y, instead of getting the goods at 100 rupees, which was the contract price, he ended up paying 120 rupees. Okay, this is the market price. So what will he say? That the goods which I was to get at 100 rupees, now I am getting at 120 rupees. I am paying 20 rupees more. These are the damages which he can claim from X. Okay. Similarly, what about Y? What if Y commits a breach of contract? He refuses or he fails to make the payment. he refuses to buy the goods, sorry. He refuses to purchase the goods. Now, in this case, X will say that you refuse to buy the goods. I would have got 100 rupees for the same, that was the contract price. You refuse to buy the goods. I had to go to the market. In the market, the price is now 90 rupees. Okay. I am getting 10 rupees less. So these damages can be claimed from the buyer who has committed breach of contract. So these are the damages which can be claimed by the buyer, and these are the damages which can be claimed by the seller. Claim by buyer and claim by seller. All right. What is anticipatory breach of contract? Anticipatory breach means breach which takes place before the due date of performance, before the due date. Now let's say that X, he promises to supply goods to Y on 13th of April and Y promises to pay on 15th of April. On 10th of April, X calls up Y and says, I cannot supply the goods. X has committed anticipatory breach of contract, section 39. Okay, this is section 39, anticipatory breach. So breach which takes place before the due date of performance is known as anticipatory breach. In this case, the aggrieved party, he has two options. He's a very angry fellow. He wants to cancel the contract immediately. So without waiting for the due date of performance, he chooses to cancel the contract immediately. Okay, he wants to cancel the contract immediately without waiting for the due date of performance. It means he wants to cancel on the date of breach, that is 10th of April. He can cancel, he can terminate, he can rescind the contract, and he can claim damages. Okay. Or he can decide to wait till the due date. He's a very kind-hearted fellow. So he can wait till the due date. Okay, wait till the due date. And even then, if X does not supply the goods, then Y has no option but to terminate the contract and claim damages. But what if, okay, I'll just write over here. He wants to wait till the due date. Now, if he is waiting till the due date, there are two possibilities. Either X will bring the goods. In that case, Y will have to keep the goods and he will also have to arrange for payment. He will have to pay for it. Okay, he will have to retain the goods and he will have to pay for it. But what if X does not bring the goods? He breaches the contract. Yes, I'm waiting. I'm treating the contract as valid, but you have not yet supplied the goods. Then Y has no option but to rescind the contract and claim damages. Okay. But yes, there is some risk involved in waiting. Y was waiting, X got the goods. Goods were kept in his godown. But fire occurred, everything was destroyed. What will happen to the contract? In this case, the contract will be discharged due to supervening impossibility. You treated the contract as valid. A valid contract now cannot be performed. You were waiting, you treated the contract as valid. It cannot be performed because of supervening impossibility, destruction of subject matter. The contract becomes void. Okay, the contract becomes void. All right. So this is all about breach of contract. Okay, I have covered actually the entire unit. What remains to be discussed is remedies for breach of contract. Okay, so that table covered everything. Apart from claiming damages, following remedies are available. Now, we are always under the impression that the aggrieved party can only claim damages, but there are so many other remedies which are available to an aggrieved party. The first one is you can cancel the contract and claim damages. See, you cannot claim damages unless and until you terminate the contract. So you rescind the contract, cancel the contract, you terminate the contract, and then you can claim damages. So you can terminate the contract. You will get damages only when you suffer damages. If there are no damages, you can just rescind the contract. Suit for specific performance. Specific performance means when the aggrieved party proves that damages are not an adequate remedy. What will I do with these damages? The goods, they are not an adequate remedy. The subject matter is unique. It is different. It is one of a kind. Okay, or it was something which was specially manufactured for the buyer. I cannot sell it to any other person. So when the goods are unique, they are one of a kind, there's no substitute available, then in that case you can go to the court and you can request for specific performance. In this case, if the court is convinced, they can insist on the aggrieved party performing the contract. So they will tell the aggrieved party that you will have to compulsorily perform the contract. So when damages are not an adequate remedy, or maybe the damages cannot be estimated, or when the contract is for unique goods, one of a kind, there is no substitute for them, then in that case you can go to the court, and the court, only this option is available at the discretion of court only. If the court is convinced, they will give specific performance, otherwise not. So the court may insist that no, aggrieved party, um, we agree with you, we agree to what you're saying, the person committing breach, you will have to perform the contract. Okay, I insist upon performance. But this is all left at the discretion of the court. Then we can also file a suit for quantum merit. Quantum merit means as much as is earned or merited. I have a separate video for it. This is the QR code of that. You can scan it and you can watch the entire concept in detail. Okay, I have discussed with example. But to discuss over here, just to recall the concept for you, let's say that X is the owner of a magazine. He has engaged Y, an author, to write a book for him. Okay, he has engaged an author to write a book for him. Now, the agreement was that X will pay him 5,000 rupees per chapter, but the money will be paid when all the chapters are published. Okay. Y wrote 3 chapters and 3 chapters were published. He prepared notes for the 4th chapter. For the 4th chapter, he prepared notes. After which the circulation of the magazine stopped. Now, is Y entitled to some money? How much? 15,000, that is 5,000 per lecture. But he had also made notes for the 4th lecture. So yes, for that, he may be entitled not entirely 5,000 plus some reasonable amount. Plus some reasonable amount for the 4th chapter because he had prepared notes. So this way, he is entitled for the work that he has done. All right. So Y is saying that yes, the contract is breached, but at least pay me for the work that I have already done. Give me at least as much as I have earned. This is suit for quantum merit. Suit for injunction. Injunction means, yes, I have explained over here, order of the court stopping, restraining a person from doing something which he promised not to do. पार्टी ने प्रॉमिस किया था कि वो ये काम नहीं करेगा, फिर वही काम करके आ गया. We can stop him from doing so by getting an order of injunction passed. You have to go to the court, get the order of injunction passed. Now let's say that X, he promised Y that I will sing at your theater only during the contract period. Okay, during the contract period, I will sing only and only at your theater and no other theater. During the contract period, he also went and entered into contract with Z. We can stop him from doing so by getting an order of injunction passed. We will remind him that you had promised you will not sing at somebody else's theater. We can stop him from doing so by getting an order of injunction passed. Go to the court, get the order. So that is suit for injunction. Now, favorite part, what are damages? Damages are nothing but monetary compensation. See, my aim is not to punish not to punish the party committing breach. My aim is not punishment. Okay, my aim is not punishment. My aim is to just provide some kind of monetary relief, monetary benefit. Okay, monetary relief, you say compensation or monetary benefit to the aggrieved party. Okay, so my aim is just to provide some kind of monetary relief, monetary benefit to the aggrieved party. What are the different types of damages? Okay, so we have ordinary damages or their usual damages. We have liquidated damages, special damages, exemplary, vindictive, or also known as punitive damages. These are disciplinary damages. nominal damages or damages for deterioration caused by delay. We also have remote or indirect damage. Let us discuss each one of them in detail. Now, when there is breach of contract and there are certain damages, so you can claim that from the party committing breach. Now, these ordinary damages are those damages which naturally arise due to breach of contract. Breach हुआ है इसीलिए damage हुआ है, breach नहीं होता तो damage भी नहीं होता. So these damages are those damages which usually arise in the course of things from breach of contract. So this is as a result of breach. Breach by seller. Then who can claim damages? Buyer. So buyer will say that if I would have gotten the contract price, I would have got it at 100 rupees. See, I discussed the same example with you. But you refused to supply the goods. So I went to the market and now the market price has increased to 120. So I am paying 20 rupees more. Yes, I am paying 20 rupees more. So that damage per unit can be claimed by the buyer. If there is breach by buyer, then who can claim damages? Seller. So seller will say that if you would have purchased in the contract, I would have got 100 rupees. But now you are refusing to purchase. I will have to sell at 90 rupees in the market. I am losing 10 rupees. I will claim it. And students, please note that the damages are calculated on the date of breach, not on the date of actual buying or selling. We are assuming that on the date of breach, if the seller would have gone and purchased the goods, तो कितने में मिलता? If the seller would have sold, तो कितने में sell करता? If the buyer would have purchased, तो कितने में मिलता? Actual sale, actual buying is not required. Now, liquidated damages, these damages they arise in the ordinary breach of contract, okay, ordinary breach circumstances. Pre-estimated damages, okay, so these are pre-estimated damages or also known as liquidated damages. Now, let's say for example that X and Y, they agreed that if the party breached the contract, they will have to pay rupees 500 per tire. Now, these are pre-estimated, they are predetermined damage because I know that this damage will occur, then they are known as liquidated damage. Special damages, they are claimed for loss of profit. If I would have got the goods, I would have sold it, I would have earned profit. I lost the opportunity to earn profit. They are claimed for loss of profit. They are claimed only when there are special circumstances. Yes, when there are special circumstances. And it is important to know that these circumstances are communicated to the other party. So they can be claimed only when there are certain special circumstances and they are communicated to the other party. What if there is no communication? Then you cannot claim special damages. You will be entitled to only ordinary damage. You will, in this case, be entitled to ordinary as well as special damages. What are exemplary, vindictive, or punitive damages? They are also disciplinary damages. Now, my main aim is not punishment, but in this case, my main aim of damages is to punish the party committing breach. I just want to teach him a lesson. I want to give others a message that if you breach the contract, you will also be subject to the same result. So here the intention is not to just recover the loss, but also to punish the party committing breach of contract. So this can be claimed in the following cases. The first is breach of promise to marry. X promised to marry Y. Okay, he promised to marry, but then he refused. Now, Y can claim damages. Feelings were hurt, my goodwill, my reputation. So, reputation, my goodwill got affected. So, these are valid grounds for claiming damages. Then next we have wrongful dishonor of check by banker. Wrongful dishonor of check by banker. X, he gave a check of 500 rupees to Y. Y deposited the check. His banker told him that the check is dishonored. Y feels कि अरे यार X के पास 500 रुपये भी नहीं है क्या, कैसे बिजनेस करता है. He called up X. अरे तेरे पास 500 रुपीज भी नहीं है क्या बैंक अकाउंट में, कैसे बिजनेस करेगा. X says नहीं नहीं, I have 5 lakh rupees in my bank. Wait, I'll check with the banker. He calls his banker and he says, banker, तूने मेरे 500 रुपीज का चेक डिसऑनर कर दिया, मेरे पास तो 5 लाख रुपीज है. सॉरी सर, गलती हो गई. अब बैंक की गलती की वजह से एक्स की तो गुडविल रेप्यूटेशन गॉट अफेक्टेड, राइट? Smaller the amount of check, greater will be the amount of damage. So he can claim those damages from the banker. So because of the wrongful dishonor of check by banker, we can claim damages, punitive damages from the banker. Nominal damages, these are very small damages. There is actually no damage, but yes, the party wants to claim they want to exercise the right to file a case, or sometimes the difference between the contract price and the market price is very less, so the damages which are given to you are known as nominal damages. Okay, so the damages are very small, 10 rupees, maybe 10 paise. Next one, very important and interesting one, damages for deterioration caused by delay in transit. Now these damages, they can be claimed from carriers. So let's say for example that X is a cap seller. Okay, he's a cap seller, cap maker. He ordered velvet cloth for making caps to be sold during the summer season, and the railways promised to deliver the cloth. But the railways delayed in delivering the cloth, and because of that, X could not make the caps on time and he lost the season. Now, the railways had given him the railway receipt. On the railway receipt, it was mentioned that the railway will be responsible for deterioration during transit. उसने वो deterioration word पकड़ लिया. बोलता है deterioration not only includes the loss, not only includes physical damage, it not only includes physical damage to the goods, but it also includes loss of opportunity. I have lost the opportunity to manufacture and make cloths, make caps. You did not give me the cloth on time. I've lost the opportunity. I want to be compensated for that. So in this case, he can claim damages even though he has not communicated the special circumstances. Can he claim special damage? He would have lost the case, because for special damages it is important that you have to communicate those special circumstances to the other party. But in case of deterioration during transit, you can claim damages even though you have not communicated the special circumstances to the other party. So they can be claimed even though there is no communication. Remote or indirect damages. Okay, remote damages are those damages which are generally not recoverable. Okay, they are generally not recoverable. No, they are not recoverable. Not recoverable. All right. Why? Because they are not because of breach of contract. They are not as a result of breach. Breach हुआ है इसीलिए डैमेज हुआ है, ऐसा नहीं है. अच्छा, let's discuss examples now. X was traveling with his wife and children. He was traveling with his wife and children on a midnight train. But the railways, they transported him to some other destination. दो स्टेशन पहले ही उतार दिया. They asked him to alight 2 stations prior to his destination. Now it was night time, it was raining, and it was very cold. They were walking towards their destination. There was no other means of transport. It was night time. Wife caught cold. Now, X claimed damages from the railways. He's saying that because of you, there was a lot of inconvenience. All right, agreed. We paid 1,000 rupees for the ticket, but you asked us to alight, and the fare till that station was only 800 rupees. So we paid 200 rupees extra. And wife caught cold. तो ये डॉक्टर का बिल है, वो भी जरा देख लेना. ये डॉक्टर्स बिल है, ये भी देख लेना, जरा सेटल कर लेना. For inconvenience, yes, we will allow the damages. For this amount which you have paid extra, okay, we'll allow you. But wife catching cold, it's not because of breach. If it would be a direct consequence of breach, then सबको होना चाहिए था. Everybody was walking in the rain. Why only the wife caught cold? It means it is not a result of breach. So this is a remote damage. It is not a direct consequence of breach. Therefore, it is not recoverable. So students, with this, we complete breach of contract. Yes, it was quick, right? That is the advantage of the workbook that you're seeing. Next, and without wasting any time, let us discuss the concept of contingent and quasi contract, and then I'll discuss questions from my compiler. What is a compiler? Yes, you are aware of it, but in case you're watching this video for the first time, this is my law compiler, which contains all the past exam questions, study material, RTP questions arranged unit wise. So you will come to know that when was a question asked in which attempt and what is the gap between those two attempts. Is it possible that they may repeat? Yes. So there is a possibility that these questions may be repeated. That trend will be understood when you go through the compiler. Compiler contains answers which are full length answers as expected by ICAI. So these are actually the answers, the model answers given by ICAI, and I have arranged everything unit wise. Okay, everything is arranged unit wise. So my model is that you first study the notes, go through the lectures, and after that immediately go and solve the questions from the compiler. So this will ensure that your concept is properly applied. You know how to apply the concept in the question. Okay, so let us go back to this. Yes, you can purchase this from my website capreetiaggarwal.com. Link to purchase the compiler is given in the description box. Going back to contingent and quasi contract. Yes, so what is the meaning of a contingent contract? You must have studied contingent liability or contingent asset in accounts. It may or may not happen. Yes, you may or may not have to pay. So contingent contract is a contract to do or not to do something. This is explained under section 31. It's the definition. You need to memorize it. To do or not to do something if some event collateral to such contract does or does not happen. Now let's discuss with the help of examples. Otherwise nahi samjhega. X obtained an insurance policy from the insurance company. Okay, so he paid premium and obtained an insurance policy. Now, the insurance policy is to protect X against fire. He will get 1 lakh rupees if the fire occurs. He will not get anything if the fire does not occur. Now, how to identify a contingent contract? Step 1 is, okay, I'll write over here. Step 1 is to identify a contract. Step 2 is to identify an independent, separate event. It is to identify an event. This should be separate, independent, it should be uncertain, it should not form part of the contract. Step 3 is the performance of the contract. Okay, performance of the contract depends upon either happening or non-happening of the event. I don't know whether I need to perform the contract or not. It depends upon happening or non-happening of the uncertain future event. Now, in this case, if fire occurs, X will get money, otherwise not. Now, let's go stepwise. Is there a contract? Yes, there's a proper contract. See, there's two parties, consideration, free consent, all the elements are present. So there is a contract. What is the event? Fire. Okay, this is the event. It is separate, it is independent, it is uncertain. When will X get the money? If fire occurs. Now, fire may occur, it may not occur. If the fire occurs, X will get money. If the fire does not occur, he will not get money. So, whether X will get money or not depends upon an uncertain future event. So, the performance of the contract depends upon happening or non-happening of the uncertain event. It's a contingent contract. One more example. X, he agreed to sell his old car to Y for rupees 1 lakh, provided he is allotted a new car by 15th of April. Step 1, identify a contract. So X agreeing to sell his old car, this is the contract. Step 2, identify the uncertain future event. So this is the event. Performance depends upon either happening or non-happening of future uncertain event. It may happen, it may not happen. Now, X will sell the old car only when he is allotted a new car. Now, he may be allotted a new car, he may not be allotted a new car. If he is allotted a new car, he will sell. And if he is not allotted a new car, he won't sell the old car. So, whether he will sell the new car or not depends upon the uncertain event. Whether he will sell the old car or not depends upon the event new car. This is a contingent contract. Next, let us discuss the essentials of a contingent contract. The contingent contract is one the performance of which depends upon happening or non-happening of the future uncertain event. This is conditional. Yes, it must be conditional. It depends upon the happening or non-happening of the event. It is conditional because it depends upon either happening or non-happening of the uncertain future event. Event must be uncertain. See, fire may occur, fire may not occur. I may get the new car, I may not get the new car. If I am very certain that the event is going to happen, then it is not a contingent contract. So, event must be uncertain. It may or it may not happen. If I am very certain that it is going to happen, then it is not contingent. Like 15th August, I will pay you 5,000 rupees if 15th August is declared as a holiday. I know 15th August is a holiday. It's not a contingent contract because the event is certainly going to happen. Uncertain event must be collateral. It must be additional to the contract. It must not form part of the contract. It must be independent, separate, different. It must not form part of the contract. It must not be the mere will of the promisor. I will pay if I feel like. Meri marzi. That's not even a contract. It's uncertain, section 29. Contingent contract, what are the rules of contingent contract? Now, please note, students, that generally a theory question is asked on this. The weightage can be anywhere from 5 to 7 marks. Okay, theory question, 5 to 7 marks. Contingent contract sometimes depends upon the happening of the future uncertain event. It means that the contract will be enforced only when the event happens. Event happens, contract is enforceable. If the event does not happen or becomes impossible, then the contract becomes void. It is unenforceable. Sometimes contingent contract depends upon the non-happening of the future uncertain event. So this was section 32, now 33. Please note one thing, students, that in this case, time is not mentioned. Okay, in both these cases, time is not mentioned. That by when the event should happen. So we will take reasonable time. So contingent contract is dependent upon the non-happening of the event. Event must not happen. Like X promise to pay 500 rupees to Y if a certain ship does not return. Now the ship may return, it may not return. He will pay 500 only if the ship does not return. If the event happens, it means the ship returns. Then the contract is void. But the event does not happen, it becomes impossible, then the contract is valid, it is enforceable. Sometimes the contingent contract depends upon happening or non-happening within a fixed time. All right, over here they have mentioned fixed time. Okay, the provisions are the same. That if the event happens within a fixed time, then the contract will be enforced. Sometimes it is dependent upon non-happening within a fixed time, then the contract will be enforced only when the event does not happen within a fixed time. So X promises to pay 1 crore rupees to Y if a certain ship does not return within 1 year. So ship does not return within a year. Will X pay money to Y? Yes. If the ship returns, he will not pay. Sometimes the contingent contract depends upon the future conduct of living persons. It depends upon how people will act in the future. So X promises to pay 5,000 rupees to Y if Z marries A. Now Z may marry, Z may not marry. If Z marries, then the contract is enforceable. But if Z does not marry, then the contract becomes void. Yes, so these are the rules of enforcement of the contract. Next and last, we have quasi contract. Quasi means they are just like a contract. So they are like contracts. One or the other essential element is missing, but even then it is a contract. See, basically my aim is to prevent unjust enrichment of one person at the cost of other. Now let's say, for example, that X, he by mistake left goods at the house of Y. Okay, by mistake, he left the goods at the house of Y. Y used the goods. Now, if Y has used the goods, he will have to pay for the goods. Now, there was no offer, there was no acceptance. Even then, this is a valid contract. It is a quasi contract. See, we are saying that why should we allow Y to enrich himself at the expense of X? Why, if you have used the goods, you will have to pay for it. This is a quasi contract. Generally, a theory question is asked on types of quasi contracts. Section number is very important: 68, 69, 70, 71, and 72. So here we have written it's an implied contract because it is implied by law. Parties never intended to enter into contract, but law बोलता है कि तुम्हारे बीच में contract हो गया. It is to prevent unjust enrichment of one person at the expense of other. See, now, although incompetent person like a minor or a person of unsound mind, okay, minor or a person of unsound mind, they are not competent to contract. But what if necessaries are supplied to a minor? Then yes, or maybe to any of their dependents or their dependents. Recovery is possible from the property of the minor. Okay, so recovery is possible. Now, this is a quasi contract because, anyways, he is not competent to contract, but still, even then, it is considered as a valid contract only for necessaries. Right to recover money paid for the other person. Now, let's see, for example, that A is a zamindar. Okay, he has given a land on lease to B, but he has not paid taxes on that land. The revenue is in arrears to the government. Now, the revenue under the revenue law, if the taxes are not paid, the government will sell the land, the lease will get cancelled. So B, in order to save his land, B, in order to save his lease, pays the taxes to the government on behalf of A. भाई A तो enjoy कर रहा है, टैक्स भी पे हो गया, लैंड भी बच गया. हम बोलते भाई तू ज़्यादा enjoy मत कर. So if somebody else has paid your obligation, so it is your duty to reimburse that person. So what are the conditions to be satisfied? So the condition is that the person who has made the payment is interested. Okay, so B is interested. What is his interest? He wants to save his lease. Okay, then A has enjoyed the benefit. And it was actually A's obligation, which the other person has paid. It is his obligation, which B has paid. And B has paid this voluntarily. So when these conditions are satisfied, there is a quasi contract. B can claim reimbursement from A. Next, we have the obligation, claim for benefit received under a non-gratuitous act. So the example which I discussed with you was for a non-gratuitous act. So here the person is not giving a gift. He's not doing it gratuitously, but he expects to be paid. If you have used the goods, you will have to pay for the goods. Responsibility of finder. Now, X found a diamond ring at the birthday party of Y. Nobody owned it, so he kept it with himself. Has he become the owner? He is not the owner. He acts just like a bailee. He acts just like a caretaker. What are his rights? See, he has incurred expenses to find the true owner. So if he can claim those expenses from the true owner. Yes. So let's say, for example, that he bought a safe, an electronic safe to keep the goods safe, and he incurred certain expenses to find the true owner. So X has incurred expenses. He can claim those expenses from Y, and if Y refuses to pay for it, X can retain the goods. So he has the right of lien. Lien means to retain. So he has the right of lien. It means to retain. He also has the right to sue for reward. So if a reward was declared and the finder was aware of the reward, then he can also claim the reward. And if he is not given the reward, he can retain the goods. He has the right to sell. So if the true owner is not found, or if the true owner is found but he refuses to pay the lawful charges, goods are perishable, or if the lawful charges amount to 2/3 of the value of goods, then under those certain circumstances, finder can even sell the goods. payment of money or delivery made either by mistake or under coercion. Now let's say that A and B, they both owe 1,000 rupees to C. Now A pays 1,000 rupees to C, and by mistake B also pays 1,000 rupees to C, by C is enjoying. It is his responsibility to return the money to B, saying that A has already paid the money. This is nothing but a quasi contract. What if A was forced to pay bribe to the railways for the goods? A paid the money, but then this is not the correct way, no, to charge money. So he can recover that money which railways has wrongfully recovered from A, or in other words, which A has paid under coercion. So in this case, he can recover that money from the railways. This is also a quasi contract. He can say, I was forced. If I would have not paid money, railways would have not given me the goods. I was forced to do so. He can recover the money. So students, with this we come to an end of our contract act, and let's quickly go through the questions also. I have identified 3 important questions from breach of contract and contingent contract. Now, this is from my CA law compiler. It has all past exam questions, study material, RTP, MTP questions arranged unit wise. You can purchase this book by visiting my website capreetiaggarwal.com. This is one book from which all the questions will be asked in the exam. So it's an exhaustive question bank containing full length answers as expected by ICAI. Okay, now see, the first question itself is very important for exam because it has been asked multiple times. Yes, so you can see it is a very commonly asked question from RTP, MTP. This trend you will be able to find when you refer the compiler. Okay, so students, an anticipatory breach of contract, it's a theory question. Anticipatory breach of contract is a breach of contract occurring before the time fixed for it. Discuss stating also the effect of anticipatory breach on contract. So basically, it is a theory question on the concept of anticipatory breach. So you're just expected to explain section 39 anticipatory breach of contract. So what have they mentioned here? Anticipatory breach is breach occurring before the due date. So yes, this sentence is important for us. This word is important, that breach takes place before the time fixed for performance. So when the promisor altogether refuses to perform the promise, or he expresses his unwillingness even before the performance is due, it is known as anticipatory breach. So you will start by explaining the meaning. Okay, this is the meaning which they have explained. Then it is purely theory. I have discussed that with you. First explain the meaning, then you can give the effects of anticipatory breach. If I would be the one answering this question, I would also explain an example in brief, in short, just one example. I would do that. So you can write the example also. Then they have mentioned section 39. Section number is important for us. Effect of anticipatory breach, you can either rescind or cancel the contract immediately. Okay, you can cancel or rescind the contract immediately. You may elect not to rescind but to treat it as operative. I had also explained with the help of a chart. You can either cancel the contract immediately, claim damages without waiting for the due date of performance, or you can treat the contract as operative, and in case the contract is performed, you will accept the performance and pay for it, or if on the due date the contract is not performed, you will cancel the contract. So that effect is explained over here. But there is some risk involved in waiting. The contract may be discharged by supervening impossibility. Now it is not compulsory that you write in these words, because this answer is given by ICI. It may sound technical, it may be a little, the language may be difficult to remember, but yes, you can write it in your own words, but try to include technical keywords and terms. If you write everything in your own words, examiner will not have the keywords, the legal terminologies to give you marks. So yes, you can write in your own words, but please ensure that you mention the keywords and you underline those keywords. Okay, so this is basically a theory question, but you see the number of times this has been asked in the exam. And RTPs, MTPs, yes, it's a very frequently asked question. Then we have question 11. Okay, let's go to question 11. Yes, I have identified this question because it is a question in which many students make error. Why? I'll tell you. What is the law relating to determination of compensation on breach of contract contained in section 73 of the Act? Oh, I have not studied 73. What if this question is asked in the exam and you realize that you have not studied section 73? You won't be able to answer this question. So through the compiler, at least you will go through all the exam questions, and even if you have not studied even a single section number, you will be able to at least remember section 73 because you have studied this particular section in the compiler. Yes. Now what is mentioned in section 73? I have not discussed it in my revision sessions because I had identified the question and I thought we'll discuss it in the question itself. Now, section 73 actually says that in case a contract is broken, in case there is breach of contract, the aggrieved party can claim the damages which naturally arise during the course of breach. You can claim ordinary damages, but you cannot claim damages which are not a direct consequence of breach. In other words, you cannot claim remote or indirect damage. That is mentioned in section 73. But normally students, when they see section 73, they start explaining types of damages. That is not the expectation. The answer is only this much. Even if it is asked for a 5-mark question, you cannot write anything more than this. Don't write types of damages. Section 73 provides that where the agreement is broken, the party who suffers, that is the aggrieved party, has the right to receive from the party who has broken the contract compensation for the damage which naturally arose in the usual course of things. It means he can claim ordinary damages because they are a direct consequence of breach. I am not explaining the types of damages. I'm just giving you a hint how to frame the sentence. So you can claim damages which are a direct consequence of breach. Breach हुआ है इसीलिए damage हुआ है, breach नहीं होता तो damage भी नहीं होता. This compensation is not given, okay? It is not given for remote or indirect loss or damage. It means you cannot claim loss for remote or indirect damage. So any loss arising from breach, it means which existed in which existed of remedying the inconvenience. This you can ignore. Okay, you can ignore this. It is not important, and it is a little difficult to remember the way in which they have framed the sentence. That is difficult to remember. This much is sufficient. If you want, you can give an example of breach of contract because you may want to create length in the exam. But this is what they expect. Now, section 73 only talks about what kind of damages we can recover. They're not explaining the damages. Okay, the remote and indirect, they cannot be recovered. So this question is a unique question. It is important. From contingent and quasi contracts, I have identified question 4. Okay, let me go to that question. Sorry, this is partnership. Okay, many questions are covered here. Yes. Again, this is a nice, unique question. X found a wallet in a restaurant. He inquired of all the customers present there, but the true owner could not be found. He handed over the same to the manager of the restaurant to keep it till the true owner is found. After a week, he went back to the restaurant to inquire about the wallet. The manager refused to return it back. X saying that it did not belong to him. ये तो तेरा भी नहीं है. In the light of the Indian Contract Act, can he recover the wallet from the manager? What do you think? Has the manager become the owner just because he has the wallet? No. Who is the finder? X is the finder. He has the right to retain the wallet against the entire world. He will give the wallet only to the true owner. So yes, he can recover this wallet from the manager. Now here you will write section 70. You will quote section 71 and you will mention the provisions of responsibility of finder. So what are the responsibilities of finder? Finder has a responsibility to take proper care of the goods, not to use the goods for his own purpose, right? No, you cannot appropriate the goods, you cannot sell the goods, or you cannot pledge the goods. You will have to restore the goods once the true owner is found. So the manager must return the wallet to X, since X is entitled to retain it against the entire world except the true owner. So manager is not the finder. X is the finder. He can take it from the manager since the true owner was not found. And then yes, X will try to find the true owner. So over here, basically they want you to write the responsibilities of a finder. Yes, he acts like a bailee. So you can write extra points over here. You can explain a few more points of a finder. And the answer format which you need to write is, I've already discussed this in the earlier lectures, but still, provisions. Now this format is not recommended by ICAI. That is why you will not find it in the compiler right now, because ICAI has given this model answer. However, for better presentation purpose, we say you divide it into 4 parts: provisions, facts of the case, analysis, and conclusion. Okay, so this is how you will frame the answer. And students, with this we also come to an end of our session on the Contract Act. I hope you enjoyed the session and we have covered the entire Contract Act in detail. You can use the Prayas revision workbook for last minute revision purpose. If you have not yet downloaded, go to the website capreetiaggarwal.com and download the workbook now. Take a printout and start filling it, write and practice. That is the only way to remember the provisions of law. Yes, also visit my website capreetiaggarwal.com for books, lectures and test series. In my next video I will start with Partnership Act. There are a couple of videos which I'm doing recorded and not live because I have other commitments, and I'm not able to match the time at which you guys are free. So today and maybe at the end of the day I will also upload a video on Partnership Act, and tomorrow we will resume. Yes, from tomorrow we will resume our live sessions. So students, I'll take your leave. Do watch this video and share it with your friends. Do subscribe to this channel and hit the bell icon so that you get notifications for all the upcoming videos.